State sovereignty. States sue Trump over ICE terror. Welcome to Law and Society. Please remember to subscribe. Today what I'm talking about are the two cases from Illinois and Minnesota where the states have sued the federal government and claimed the violation of the 10th Amendment. I'll read you the introduction portions of these two cases. Their full complaints are in the description box of this video, so please do check them out if you want to read the full complaints. And then there is the order from the Minnesota federal judge that is stopping ICE from conducting certain activities in that jurisdiction. So first I'll read you Illinois' complaint and the introduction of their argument, and then I'll read you Minnesota's. And then I will read you the individual plaintiff's lawsuit that preceded these state cases and occurred and was filed before Renee Nicole Good was murdered by Jonathan Ross. So, Illinois says, the federal menacing, violent, and unlawful incursion impedes Illinois and Chicago from carrying out core sovereign functions in violation of the 10th Amendment. The Amendment preserves Illinois' sovereignty. That sovereignty is not just an end in itself. Rather, federalism secures to citizens liberties that derive from the diffusion of sovereign power. Federalism protects the liberty of the individual from arbitrary power. Defending conduct has hindered the improvement and prosperity of Illinois and Chicago and offended the core notion of dual sovereignty. This impermissible interference in state sovereignty is not within the enumerated powers of the national government. It also violates the Administrative Procedures Act many times over. Each of the actions that accompanied Border Patrol's incursion exceeds defendants' statutory authority and is arbitrary and capricious, including sending armed agents to roam streets and question those they encounter about their citizenship, capturing and retaining biometric of people they encounter without consent, arrest without a warrant or probable cause, deploying tear gas in the neighborhood among residents going about their daily lives, initiating enforcement actions at courthouses, schools, medical facilities, and other sensitive locations to intimidate those who seek public services, hiding their identities and avoiding accountability by concealing and stopping vehicle identification, and trespassing on property belonging to the residents of Illinois and its government. Illinois and Chicago seek to vindicate their sovereign authority to govern, grow, and maintain public order and stability against an unchecked federal government seeking to coerce Illinois and Chicago to do its bidding through brute force. So that's Illinois. Here's Minnesota's short introduction about what their case is about. The 10th Amendment gives the state of Minnesota and its subdivisions, including the cities of Minneapolis and St. Paul, inviolable sovereign authority to protect the health and well-being of those who reside or visit within their borders. The people of Minnesota are entitled to basic safety and dignity in their communities. They have the right to move about their lives confident that their constitutional rights and civil liberties will remain intact and will not be infringed. They have the right to go to work, take their children to school, and move through public and private spaces free from fear of violence against themselves or their loved ones by their federal government. They are entitled to access city services and use city facilities without being harassed by federal agents in parking lots. They expect that law enforcement, whether federal, state, or local, will follow the law, avoid creating dangerous and chaotic circumstances, and conduct in a manner that distinguishes officers from masked criminals. When the federal government itself violates legal rights and civic norms on a broad scale and public panic is high, state and city governments bear the costs, both tangible and intangible. Agents' reckless tactics endanger the public safety, health, and welfare of all Minnesotans. An unlawful tactic used by defendants' agents have left members of plaintiffs' communities afraid to shop, go to work, attend school, access basic services, or otherwise live their lives. Plaintiffs bring this suit asking the court to enjoin further legal violations and harmful escalations by defendants and prevent further harm to plaintiffs. So, this happened last week or so, and in that time, Donald Trump has already threatened to invoke the Insurrection Act and has put 2 military battalions on standby to be sent into Minnesota should he invoke the Insurrection Act, despite the fact invoking the Insurrection Act includes several preconditions that Donald Trump has not factually or legally satisfied. But that's really not going to stop Donald Trump from sending in the military and then litigating the case in court while the military is blocking access to peaceful protesters and observers of what federal agents, Donald Trump's federal agents, are doing. So here we have the military cover up by blocking access, using taxpayer money to build a private army of ICE agents, and then using the Insurrection Act to bring in the military to block our access to the truth about what federal agents are doing, including their murders and their abductions. So it is important to note that Donald Trump is not stopping his police state. With every step, with every moment, he is increasing and ratcheting up the authoritarianism that is emblematic of his regime. So in that sense, the federal judge in Minnesota has put a foot down and has stopped Donald Trump's encroaching police state. A federal judge in Minnesota ordered ICE to stop their overreaching actions on protesters. So in this case, 6 named plaintiffs who have protested and observed these enforcement activities, their First and Fourth Amendment rights have been violated and request both declaratory and injunctive relief in addition to demanding relief on their own behalf. They also seek to represent a class of persons who record, observe, and protest the immigration and officers and their efforts. It is hereby ordered that plaintiff's motion for preliminary injunction is granted. This order applies to individual plaintiffs and to all persons who do or will in the future record, observe, and or protest Operation Metro Surge and related operations that have been ongoing in this district since December 4, 2025. This injunction applies to defendants and their officers and agents operating in the District of Minnesota to conduct immigration enforcement activities as part of Operation Metro Surge. It also applies to defendants and their officers and agents responding to protests that arise in response to Operation Metro Surge, herein covered federal agents. So we'll be calling them covered federal agents. This injunction does not apply to defendants and officers and agents otherwise conducting routine operations within the District of Minnesota. Covered federal agents are hereby enjoined retaliating against persons who are engaging in peaceful and unobstructive protest activity, including observing and activities of Operation Metro Surge, arresting or detaining persons who are engaging in peaceful and unobstructed protest activity, including observing the activities of Operation Metro Surge in retaliation for their protected conduct and absent a showing of probable cause or reasonable suspicion that the person has committed a crime or is obstructing or interfering with activities of covered federal officers, using pepper spray or similar non-lethal munitions and crowd dispersal tools against persons who are engaging in peaceful and unobstructive protest activity, including observing the activities of Operation Metro Surge in retaliation for their protected conduct, stopping or detaining drivers and passengers in vehicles where there is no reasonable articulable suspicion that they are forcibly obstructing or interfering with covered federal agents or otherwise violating statutes. The act of safely following covered federal agents at an appropriate distance does not by itself create suspicion to justify a vehicle stop. Dissemination of this order must go to defendants. Widely disseminate notice to all covered federal agents, including providing copies in paper or electric format. The order must be distributed to all covered federal agents and all defendants within 72 hours of its issuance. So that is the order, and it will remain in effect until Operation Metro Surge concludes or the conditions change such that it is no longer necessary. If any parties believe that the surge has come to an end or the injunction is no longer necessary, they may file a motion for its termination. So, with that, the District of Minnesota, it has barred the federal agents from conducting their brutal activities as they have been since December in the District of Minnesota. Now, whether other federal judges adopt this and stop the ICE agents from First and Fourth Amendment rights depends entirely on whether they are sued for it by individual plaintiffs or not. Then we're also going to be hearing about the different courts in Minnesota ruling on the relief that has been asked by the states of Illinois and Minnesota in their lawsuits with the federal government. When that ruling comes out, I'll come out and talk to you more again. Until then, thank you so much for listening, and I'll come back with other topics very soon. Remember to subscribe and like, and I will talk to you soon.